we're going to be talking today about what appears to be a simple topic, but is often misunderstood by attorneys and more often by clients, and that is the attorney-client privilege. I can just hear your managers and directors saying to you, well, you're an attorney, I'm a client, we're communicating, therefore this must be privileged. Well, you wouldn't be here today if it was as simple as that, because it's not, and you know that it's not. So we only have an hour today, so there's a limited amount we can cover. We're going to try to cover some more of the common situations. I'll be talking about the basic fundamentals of the attorney-client privilege, because Jessica and Reed don't trust me with something more complicated. And Jessica will address investigations. She's uniquely qualified given her background and her experience. And Reed will talk about litigation situations. So let's get going. The basic fundamental questions you're going to have to ask yourself over and over again of whether a conversation is privileged. It's only privileged if you have an attorney communicating legal advice to a client seeking legal advice in the context where the conversation is confidential, usually meaning shared with no one other than the attorney and the client. Without all three of those elements, there is no privilege. Now, for outside counsel, this is typically not very complicated because we're almost always giving legal advice. No one calls us for business advice because very few of us are familiar enough with a particular client's business to offer any meaningful advice. So secondly, identifying the client is typically not a problem because of the person calling you, paying your bill, and we make sure to specify who specifically the client is in our engagement letter. And every time we have a conversation with a client, it of course is confidential. Ethics require it to be kept confidential, not only outside counsel, but in-house counsel are subject to the same ethics rule. But for in-house counsel, this is a much more difficult process in terms of who your client is, what capacity you're communicating, and in the typical day where bombs are firing off all over the place and you're in the heat of the moment and people are coming in and out of your office, they're calling you, you're receiving emails, you rarely have the chance to have a few minutes of quiet contemplation to decide, well, is this conversation I'm about to have privileged? So we recognize that, and we're going to give some tips today on that may help you, but we recognize how difficult this is in an in-house setting. The first question you've got to answer is, who is your client? Well, y'all all know that your client is the company that you work for. Your client is not the directors, they're not the managers, they're not the officers, they're not the employees. You represent the entity. You can't represent the directors or anyone else in their individual capacity while you are representing the client or the entity. Again, that's a rule that's easy to state, but who is your client? And it's made more complicated because there's three different tests to identify who your client is. One is the control group test, which basically says your client is the people that control the entity, the managers and directors that control the entities, and anyone else who plays a significant role in acting on any legal advice you're giving. That's the minority rule. That's the federal rule. It's not the rule in Texas. The subject matter test is a broader, or thought to be a broader test. It certainly reaches further down into the management ranks of a corporation. And the subject matter test is any employee who's communicating with a lawyer and has been directed by their superiors to communicate with a lawyer, and again is within their scope of employment to take the action that the action given by the attorney. That's not the Texas test either, but it is the majority rule. The Texas test is set forth in Texas Rule of Evidence 503. It's basically a combination of the control group test and the subject matter test. So it's a little easy, it's a little broader than either test because it includes elements of both. So it's oftentimes easier to identify the client under the Texas. And if you ever have any questions, you go look up Texas Rule of Civil Procedure. The case cited at the bottom of the slide and others like it, you've seen a lot of them lately, where this issue of who is in-house counsel representing has come up. Oftentimes, employees think you're representing them. When you're not. And in the Elizabeth Home case, and I think there's just been a SoftBank case, a WeWork case, where employees were able to break the privilege because they were able to convince the court that they believed that the lawyer in question was representing them individually. And like I said at the beginning of this, non-lawyers are the ones that have the most misunderstanding of the nature of the attorney-client privilege. And it puts the burden back on the attorney to make sure they understand the scope of your legal representation.
Bill, can I chime in for just a quick second on that point?
Sure.
It's a great point, and another way of looking at that same issue that we dealt with some at the SEC are instances where a company needs to be thinking about protecting its privilege even after an employee or an executive has departed, and that individual becomes the recipient of, for instance, a subpoena for documents or testimony, and that person might rightly want to provide all of that information, but the privilege actually belongs, as you pointed out, to the company client. And so counseling people in the company and as they leave the company about who owns that privilege, who is the client, and then as possible trying to be vigilant and aware of those issues even after the fact is important. So I think it's a great point. I just wanted to add that additional perspective.
Yeah, and again, as we were putting together this presentation, we realized that the target audience is probably non-lawyers who work in corporations so that they understand better what's privileged, what's not privileged, and we're going to touch on that a few times. But once you've identified the client, then the next big issue, and the one which we see the privilege challenge the most, is the dual capacity of in-house counsel, where they are not rendering, nobody's seeking legal advice from them, or they're not rendering legal advice, and the court determines that the communication is not privileged. It's surprising to many people as well that courts construe the attorney-client privilege relatively narrow, especially in in-house lawyer cases. In outside counsel, there seems to be a more leeway, or an assumption at least, that the conversation was privileged. With in-house situations, not so much. And the common thing we see is copying in the attorney on emails related to a business issue or something going on, again, with the thought from management that, well, if we copy in the attorney, everything's privileged. If we invite the attorney to our meeting, then everything's privileged. Well, that's just not the case. Courts routinely disregard a carbon copy to a lawyer and look at the substance of the communication to determine whether anybody was seeking legal advice, whether anybody was giving legal advice, and whether the communication was confidential. If you're copying people outside the control group test or the subject matter test, then that's not a confidential email because they aren't clients. So it's a much more narrower privilege that you have to be aware of. And speaking of confidential, like I said, copying people outside the client group, communicating with people outside the client group is not necessarily privileged. Now, there are some situations, for example, and maybe Jessica will get more into this, but you may be called upon to communicate with employees to gather facts in order for you to give advice to the client. And those communications can be privileged. The facts are never privileged, no matter what context they're in. But the communications that contain the thoughts, processes of the attorney may be privileged. So one of the recommendations we make is when you're acting in that role to identify that in your email, saying that I need to talk to you because I need information in order so I can talk to the client. One thing, especially those who work for companies with overseas operations, there are some countries that simply do not recognize the in-house attorney-client privilege. And if you're in that situation, you need to make sure you understand that and understand that any of your communications, whether or not for legal advice or otherwise, are not going to be privileged. So we're basically, again, you need all three elements in order to have the privilege. Any one of those elements that are missing is not privileged. I'm going to talk briefly about email, and then Jessica's going to talk a little bit more about specific situations. Email is by far, and I don't have to tell you this, the biggest problem that corporations face and attorneys face in keeping communications privileged. It's too easy to forward emails. It's too easy to do strings. So a couple of things that we need to keep awareness of. First of all, limit the use. Try not to put particularly sensitive privileged information in email. Now, I know, having said that it's just too easy to use email, and you can have multiple conversations going at the same time. You don't have to stop down and try to get a telephone call going. But if you're going to use email, make sure your email conveys the purpose of your email. Identify the email as confidential. If you've got the ability to limit forwarding or printing the email, use that option on Outlook. Outlook purports to be able to do that. Don't know whether it actually works or not, but you need to check with your IT people. Jessica is going to address the issue with directors. And I think this is a situation we work where directors were using their own personal email and the privilege was waived. But I just want, before I hand it off to Jessica, I just want to mention an aspect of Outlook that may make it easier for you to stamp emails with custom messages. It's something called Quick Parts. If you'll just Google Quick Parts or go to Outlook and figure out how to use Quick Parts. But what Quick Parts is enables you to put together a library of commonly used phrases that with 2 clicks you can insert in the email. So these phrases we tell you to use, such as confidential attorney-client privilege communication. I'm sending you this email because I need information to advise the client. You can set up those in Quick Parts, and when you need them, you use them, because if you're stamping every email confidential attorney-client privilege, courts are going to be more likely just to ignore it. But if you're selectively using it when it's really appropriate, that may be all you need to keep that email privileged. You need to be particularly aware of email strings. If suddenly you don't know who's on the email unless you read all the way down the string, and sometimes if you're on a mobile device, you may not even have the ability to see everybody on the string. And so our recommendation is that you break that chain, especially if you're going to be offering up some confidential attorney-client privilege. You just start a new email and you send that email only to the people that need to get it. That's the same advice for reply to all. It would be ideal if you could disable reply to all, or most of your systems can have a warning that comes up and says, do you intend to reply to all? Our system will put a screen up and let us choose who not to, or get it or not, but I don't trust that. So again, I start a new email just to the people that need to be involved. With that, I'm going to hand it over to Jessica and particular situations that come up in investigations.
Sure. Well, I think Reed's got a quiz he's going to give in a
Oh,
second,
does
but
Reed have a quiz?
I wanted to address a couple questions that have come in. Bill, you're saying quick parts, P-A-R-T-S, correct?
Yes.
Good. Yeah, and
it's
that's
different. There's another feature that kind of does the same thing, but it's the quick parts feature that once you get your phrases set up, 2 clicks and the phrase gets stamped in.
Yep. Good, thanks. And then another question that came up, and I'm not going to be able to get through the few that we've received, but I wanted to address this one now. And as we go, we'll get to the others that have come in. In situations where a person's in-house and their job, and this is, I think, true for any in-house counsel, is regularly a mix of law and business. In-house lawyers, as we often know, are chief miscellaneous officers. They can, in the same conversation, be giving legal advice and operational advice, or at least operational interface. What do you do in a situation like that? How do you communicate? And I'm sensitive, having been in that position and worked with many people that can be tough when people don't want the lawyer to be overly technical, or, always the cop on the beat, trying to make sure everything is, perfectly categorized. But I do think it's important for the in-house lawyer to try to be situationally aware. So when you're sending an email, preferably not text messages, but when you're sending an email that might have that mix of information, be situationally aware as you're able, and bifurcate it if and as you can. What is legal? What is business? So that if you get into a situation later where a person wants to challenge or call into question that privilege claim, perhaps your not best, but worst case scenario is that the communication ultimately is disclosed, but with the legal portions redacted, and the business communications only disclosed. Arguably, though, if you can show, and we'll get to this in a little bit, that the primary purpose, or in some jurisdictions, the predominant purpose of the communication was legal, you can sort of tip that scale. So think about, what is it I'm needing to communicate? I understand there's a mix of business and law. If it's mostly law, how am I going to create that indicia using quick parts, or, a stamp on it, and then saying, I'm providing you feedback on your question about the law or this legal issue, and then weave in the business or bifurcate the business as the circumstances warrant. Which, Reed, I think takes us nicely to a case example that you have to give us where a court took up some of these very issues.
That's right. Let's see if I can get over here. Okay, so this is a case that was in the Southern District in 2020. I think it was in April. And this is another thing to be aware of that I think is important, is that when a lot of times when we're thinking about privilege and our involvement, we might be thinking just about, whether you're the plaintiff or the defendant, but also in this situation, this was a third party. So you might think that you're fine, you're not involved in the litigation, but then you get dragged into it, and then at that point, your communications and what you've been doing are now going to be subject to litigation. And so this was a case that involved a electric company that was the third party, and they had sold turbines to a government contractor that had then contracted with Angola to sell these turbines over there. And then a discrepancy came up between the contractor and the government in Angola, and so then the lawsuit ensued between them, and they then sought to get communication from the electric company. And so the electric company had produced some emails, but then attempted to claw back 3 different email strings. And what I'm going to go ahead and do is we're going to describe those email strings. So we're going to take a poll as to whether everyone thinks that those were found to be privileged or non-privileged. So the first one was an email string between some of the parties that described a meeting that had taken place. And then the electric company had forwarded that to their in-house counsel. So the initial email had non-parties, but this one was just the in-house counsel. And the person said, "Can you opine here?" And then that was forwarded to additional in-house counsel, and they started talking about other meetings. And so the company just had held that back, saying that by forwarding on to their in-house counsel and asking the in-house counsel to opine here, that was seeking legal advice, and so that email string was therefore privileged. So the second email string is an email that was the company's CEO forwarded some information, a contract they had received to in-house counsel, and had asked the in-house counsel certain questions dealing with the document, and some of it had to do with accounting issues and that sort of thing. So the in-house counsel then, to answer those questions, started forwarding it to other employees, to non-lawyer employees, to get the information to answer the CEO's question. And so again, that had been produced, but then they clawed it back. And then the third email was, again, an email that had been sent from one of the employees to a group that included in-house counsel. And the in-house counsel had then, in responding to the other folks, said that, when they forwarded it on to another non-party, that they needed to not include what was quote unquote intra-company commentary, and that advised the other folks that there was nothing untoward about what was being sent on. So that was the crux of the communication that the in-house lawyer had said to the employees. So I guess we're gonna go ahead and do a poll now. So for each of the three emails, please go ahead and vote whether you think that the court found that those emails to be privileged, or that those emails were non-privileged. Okay, so the first one, it looks like 40% thought that email was privileged, and 60% said non-privileged. And so the 60% were in the correct camp. So the court found that email was in fact non-privileged, that even though a declaration had been submitted in support of the motion to quash, and that said that he had sent it to his in-house counsel for seeking some legal advice, the court found that it wasn't a dominant purpose. And looking at the factual scenario, one of the things as well was that in-house counsel had been present at the meeting that was described. So even though the words opine here were used, the court found it was really more of just saying, "Hey, I wasn't at that meeting. Can you tell me about what happened, or is this accurate," or that sort of thing. The court found all three of those to be non-privileged. And in fact, in reading some of those, you might be surprised. And before it went through its analysis, the court even said that the electric company that was the subject of the motion has not even come close to meeting its burden of showing that the clawed back emails are protected by the attorney-client privilege. So I guess, again, so on the second one, we had 40% saying that they thought it was privileged, and 32%. And with the second email, the court, part of the reason I like this case is because the court had some great quotes and some great tidbits. But the court said that with that one, even though the CEO had asked the in-house counsel for advice, when the in-house counsel started involving the non-attorney employees and asking them questions, that the court said that even though there may have been somewhat of a little aspect of that was maybe seeking legal advice, that the court said that a whisper was drowned out by their accounting treatment discussions. So again, just because the attorney may have been involved and it may have been seeking legal advice in the beginning, the true answers and everything came from the accounting folks, and that's where everything came from. And
Reed, do you think there would have been a different result on that email string if the in-house counsel had written, "I've been asked by the CEO to gather some facts related to this, so that I can give legal advice to the company"? Would you think that made any difference, or was this court just being really nitpicky?
This court seemed to be a little bit nitpicky, but I do think that would have helped, because the court even said, look, when all we have to go on is the facts and what I see here, that's, that's what we have to go on. And so that's kind of where the court is having to do jump balls. So I think that had the court had some of those things, said, this is for the purpose of providing a legal opinion, or, we're seeking, but I think that based on just the circumstances before the court had to say, look, to me, what does this look like? What does this smell like? Does this look like legal advice, or does this look like accounting advice? And again, the court said that the legal advice was just a mere whisper amongst the accounting advice. And the court did the same thing with the third string. It said that, even though it looked like the lawyer was kind of maybe giving some legal advice because of how short what the attorney had said, it looked more like he was just kind of giving some, kind of a strategy for what to do, but that it didn't appear legal in nature. So again, rather than saying, this, there's nothing untoward about it, maybe you could have said something to the effect of, we need to keep in mind that this could always potentially be subject to litigation. So when we're communicating about this, remember this, or, before that, please ask them to come talk to counsel. But I think just making sure that that advice was not just viewed as sort of a business strategy, but had the lawyer really couched as, this is my legal advice, or that would have I think changed on that one as well. So sorry, that was kind of tricky, but yeah, all three of those email strings were found to be non-privileged by the court.
Well, and as in-house counsel, you all have 100 things on your plate every day. You make a list and then immediately discard it because the business and legal demands of the company are pressing. And we're talking about situations where many months or years later, communications that frankly may be had by counsel that no longer work at the company, people that are no longer there, or that faulty memories just can't perfectly recall, are being pulled into chambers and reviewed in camera. So everything that you can do real time to thoughtfully indicate when you mean for privilege to attach and why you mean for privilege to attach will put you in a better position later. So those principles that Bill is talking about, break the chain. Don't let your lawyer's voice when you're communicating for a legal purpose be drowned out by the noise, and I mean that with love and respect, of your business peers, and continue to manage up, out, and down about the importance of this and protecting company confidential communications, against future adversaries. The concept also of documenting when you're claiming privilege is an important one. Reed, we can go on to the next slide if you will, please. A lot of times companies are dealing with and considering, you can go back, I'm on file memos, thanks. Considering legal issues and advising the company within the company without the need of outside counsel. And that's perfectly appropriate and fine. And the law is well settled that you have privilege in doing that. But when there is an issue that's particularly sensitive, you're doing a deal and you want to make sure you have the business judgment rule, or you are looking at potential new product, or anything where you're dealing with it internally, but you definitely want to make sure that dual roles or question about whether you're acting as lawyer at the time or the extent to which you are, it is perfectly appropriate to put a memo to file, to segregate that memo. That's another indicia that you can, or the company can later use to indicate that we took this seriously, we intended it to be privileged. When you're engaging outside counsel, either newly or a new matter as it arises, be it potential litigation, or you need advice essentially on a deal or financial planning, whatever the case may be. If you think that there is the potential for question or challenge later, again, file memo. I know of at least one, and I'm sure there are several instances where regulators, in this instance, the SEC, did stop short in its investigative inquiry where the company, which was a registrant, said, here we have a file memo shown, and it's brief, less than a page. On this date, I in-house engaged X outside for the purpose of helping me to provide legal advice to the company, and to him or herself provide advice to the company on matters related to blank. The staff stopped its inquiry at that point and did not discover or seek to go into further communications around that, because there was indicia that the privilege was being claimed and protected, rather than what could be argued as self-serving post hoc statements about, yes, that was privileged. And that's separate from issues where a party might claim good faith reliance on advice of counsel, which we all know can create its own issues of waiver. We have in here, best practices, which are not always and often are not available, are for in-house counsel to be the person or people engaging outside counsel and managing the business with outside counsel. That's not always achievable. And frankly, the day-to-day business of working with bankers, for instance, real estate transactions, the lawyer is in-house is not the person most equipped to have those conversations. So thoughtfulness around your policies and procedures, authorizing or directing people, enabling them through some sort of recorded, communication that, go and do, are good ways to maybe protect that later. I want to touch back a little bit, and this is on the next slide, Reed, on dual roles. Bill touched on this a little bit. Dual roles are increasing in their frequency. We see them more and more. Legal departments, compliance departments are cost centers, not revenue generators, and more companies, for very good reasons, are either by title combining roles, or just in fact and circumstance combining roles. So I'm talking here about GC CCOs, GC COOs. Sometimes you'll see a GC CFO. So that's even a little more distinct than just a person whose title is general counsel or chief legal officer, but they also stretch and straddle into business operational roles. I'm talking about a person who by title is meant to do different things. That is a very, very frequent basis for challenging the privilege. It's something that companies certainly can navigate, but need to be very aware of, and need to have thoughtful conversation and plan, determine whether there should be policy around that, or a habit and repeated practice that can be discussed and demonstrated to someone that might want to challenge that later, that no, we're very pinned down. We understand that we have a person in a dual role, and here's how we navigate those issues appropriately, so that you can't just come in and sweep privilege away from all of their legal communications. So some things to think about there, and frankly, this could be a whole hour of its own conversation. Situations where you might see a GC also acting in a finance or a finance and planning or financial officer controller perspective, where they, as a natural part of their business, are going to be talking about the accounting, the financial results. Perhaps their auditor has identified a significant deficiency or material weakness, which could require a person to provide both legal advice to the company and also financial input and advice to the company. Great care and thoughtfulness is required there, and what communications are reduced to writing, and who is present for communications in person or virtually, as the case may be these days, to protect that privilege, or to know this conversation will not be privileged because it is predominantly, as Reed said, an accounting an auditing related discussion, not a legal discussion. So planning and management and education of your other executives' expectations is key there. From a regulatory perspective, we know that the SEC, especially in this region, does take a very close look at dual roles, especially around general counsel, chief compliance officers. The head of the exam program in this region, Marshall Gandy, has often said, he feels that there is, a question mark at least around the natural tension between being a GC and a chief compliance officer, where one is meant to be the company's chief advocate, while the other is meant essentially to be, at least in large part, internal affairs. So reporting lines for dual capacities are very important. Is your dual titled person reporting through operations, or are they reporting through legal? Who is their direct report, and how do you procedure around the bifurcation of their duties? And one other touch on dual roles that I'll make is also from a regulatory perspective, we see frequently companies that have outside counsel, and through their outside counsel, they want to engage third parties. Compliance consultants are often engaged through counsel in an effort to maintain privilege for the benefit of the company's communications and receiving draft reports, things of that nature under the Covell case. That's another area where regulators have often been seen to respect that privilege, but will sometimes poke and try to pierce. So thoughtful planning around who the in-house legal team is, working with the outside legal team and any third-party vendors sought to be engaged through that relationship.
Jessica, I think this might be a good time that we have a question that says, so based on what you're saying, would it be appropriate or break privilege for outside counsel to communicate directly with the business partners facilitated through in-house counsel?
I think that so I'm going to say it back. Hopefully I'm getting the question right. So Jessica Magee as outside counsel wants to speak to the chief operating officer or someone in that person's line within company. Ideal state is that the in-house lawyer is part of a meaningful and substantive part of that communication. And it is understood through our habit and practice that I am communicating directly with operations in order to provide an authorized person, an agent for the company, to solicit and receive legal advice in connection with whatever operational thing is happening. So operations wants to oversee deployment of a new financial product, or HR is thinking about changing how it onboards employees, or whether employees are exempt or non-exempt for overtime purposes. If you structure it where in-house counsel is involved, or at least is involved in the establishment of the relationship, and then you touch back on that regularly in your own communications between Jessica as outsider and just the insider executive outside of legal, indicate that it's for a legal advisory purpose. Those indicia should give you protection, but do not necessarily protect you from challenge. And the challenge would be that this is a non-legal in-house company employee. And then you're going to say, did they waive, or was it not privileged to begin with? And then a third issue that comes up is, even if it was privileged and it wasn't waived, is there some exception, like crime fraud being the most frequent, which is going to be, fairly atypical, but certainly something that we could discuss.
Certainly not with anyone on this call.
Certainly not.
Certainly not.
So, okay, sure.
You want to address the director?
Yeah.
issue
Yeah.
quickly, because that's a very common problem.
It is. And it's a normal problem. And it's something that sounds very easy to address and resolve, and is much harder in practicality. And that is the issue of protecting privilege when you are communicating with members of your board of directors. Directors are busy. They often have day-to-day jobs, and they often are on other company boards. How do you protect your privileged communication with the director when you want to make them aware of the status of an investigation, of a litigation, of a deal that's about to close? Ideal state, again, is that you have perhaps a board portal like Diligent or Board Vantage, and that you have awareness about turning off, my recommendation, the tools that track how long when a director has logged in, or how long they're logged in, because you don't want to create discovery around that separately. That's another conversation. But that creates a secure portal, or another secure platform by which you can have a privileged, confidentiality being key, communication between the lawyer and an agent of the client. Oftentimes directors don't know how to, they lost their password to get into Diligent or Board Vantage. Next best case scenario is to set up emails for your directors. So I work at Acme Corp. In-house lawyer at Acme Corp. I'm going to set up a director at Acme Corp email address, and I'm going to communicate just to that special purpose email address with that director. Again, I'm protecting, it is secure. I am intending to provide and receive solicitation for legal advice over a single channel. Again, directors may say, I don't want to keep up with a bunch of email addresses. I lost the password. How do I put it on my phone? So what you often see are directors who will ask you to just communicate to their most frequently used email address, their day-to-day employer, or another email address provided to them perhaps through another board. That can create low-hanging fruit for waiver challenges, it is incumbent upon you and the director to understand what the policies are around the other email network. So in the WeWork case, which is up here on the screen, WeWork was suing SoftBank on the failure of the $3 billion stock purchase deal. SoftBank had people seconded to WeWork and to Sprint. A couple of people communicated through their Sprint emails. Sprint said, hey, Sprint people, you have no reasonable expectation of privacy. And they had no hard ban on a use of personal email. So when individuals communicated with the expectation of privilege to WeWork and from WeWork, SoftBank, but to a non SoftBank email address, it opened those communications up for production. It's really sort of a story of scared straight, and it requires, I think, engagement early and often with directors and with your C-suite that manages the board to say why it is important. It is another expectation you're laying at a director's feet, and you're asking sometimes directors that don't want to learn how to use a new portal to do something that they don't want to add to their list, but it is for their own protection and the company's protection. And frankly, in a situation where I, in-house lawyer, am emailing my director and director works at other company emailing that person in their employment capacity may also have issues because we've now put a hole in the security of their network by putting other company privileged materials into their server.
Well, and Jessica, it creates an ethical problem of the in-house lawyer, because that communication was, lawyers have an ethical obligation to keep client communications confidential. If you send an email out to another company address or something like that, it creates a confidentiality problem. Yeah. It's an ethics problem for the
That's right.
For the lawyer that sent it. What I found may be effective with directors sometimes, or top executives, is to explain to them that if they are doing company business on a personal device, when a subpoena comes in, when a request for documents come in, someone must then look at that personal device and find out if there's any responsive emails on there. And if heaven forbid, government shows up at the door with a search warrant, they will take those phones themselves and copy everything on them and tell you they won't look at anything that's not relevant. But that may scare them straight enough to where they may pay attention, because for some people it would be a nightmare to have their phone seized and searched.
It should be a nightmare for people. We've had a question come in about, if a business person records a call where legal advice is given, what are the rules in Texas about whether the communication is privileged? It's an excellent question, and I don't know that I have the perfect answer to that, but I will say, and many people know, Texas is a one consent to record state. So you want to encourage healthy habits among your colleagues within your org, that we don't record calls. I mean, I made again, I'm reverting back to my regulator days, but I made a number of cases based on the fact that companies decided to record all of their internal and external communications. It made my job very easy. And I'm going to get to something here in a moment, and I want to be aware of people's schedules, so I'll cruise through it. But in this virtual world, if you're engaged in an investigation, for instance, you need to be certain that in your upjohn notices or your outside counsel's upjohn notices, which are notices that say, hey, person I am interviewing, I represent the audit committee or the board. I do not represent you. You must elicit agreements from them that they are not recording, that they're not video recording, audio recording, that there's not a person off camera with record on their iPhone, because it is a big back door that you can fall through on privilege waiver.
Yes, and Jessica, listen to what Jessica is saying here about the recordings. The reason email is quote unquote problematic is because it creates a real-time documentation of what was actually said. In the old days, before email, we had to question people about what was said on the telephone call or in a conference, and they couldn't remember and we couldn't prove otherwise, et cetera, et cetera. So by recording a conversation, you're just turning it into evidence to be used against you at a future date. A lawyer cannot ethically secretly record a conversation, but in the question, that business person can in fact secretly record you as long as the business person is a party to the conversation.
Yeah, but I think another thing that's important, Bill, kind of to your point, is obviously we're talking about emails and that sort of thing, but even just these rules apply to the advice that some of these folks might be giving as well, whether or not, those communications, whether even those conversations would be discoverable later on. And, so even just a talk that, the advice they might give, I think still the court, whether they would compel a witness to discuss it, is going to come down to whether the advice was business advice or whether it was legal advice, and who was seeking it. But I mean, so while we might be talking about physical things, also this could come up in a deposition or something like that, just
Right.
for the communication.
Well, and I'm not suggesting that you don't document things to avoid prosecution. The problem with email is, Jessica's already alluded to, it'll be 2, 3, 4 years down the road when somebody's looking at that email in a completely different context and trying to figure out, well, what did they really mean when they were saying this? What does that little emoji mean? It's a winking emoji. Were they saying, hey, this is secret, don't tell anybody? So that's the issue with contemporaneous recording, is if we were going to be looking at this next week, that would be fine, but it's not. We're going to be looking at it down the road and trying to reconstruct the facts around it, and that's almost impossible to do.
I'm going to try to get through investigations in 5 or 6 minutes so we can save a couple minutes for litigation and any other questions. But I'll say, you're welcome to call me, email me, any questions. I can nerd out on this stuff and talk about it ad nauseum. So happy to field anything offline that anybody would like. When we're talking about email, you should just think that we're saying email and text with bigger, redder, scarier red lights around text messages. There is not an internal investigation that will happen now where somebody's not going to be asked, well, do you text message about work? And if you're an in-house lawyer texting with executives, that's a very scary area, because I can think of many audit chairs I've met, many CEOs, many COOs that are very busy and with perfect, pure intent, fire off a quick text from a car from meeting 1 to meeting 2 saying, lawyer, what's the status on deal? Are we going to get term? And then lawyer, wanting to be a good steward of the company, needs to get CEO, COO quick information and responds. That's a privileged communication, but it exists potentially on personal devices. So these issues are there's no perfect answer because it's so fact and circumstances intensive. But these are the things we really encourage you to be talking about and engaging with your management teams about. So when you are in an investigation or you are preparing to launch an investigation, everyone on this call has either been in or know of a situation like that in your companies or other companies where you've worked or served. There are many, many potential audiences. And Reed, you can go on to 19 if you don't mind. Many audiences, whether they're your now audience or your future audience. And among those audiences, many, many, many are not in the trust tree when it comes to privilege. And many, many, many would love nothing more than to pierce privilege. So it is incumbent on in-house counsel when you are kicking off an investigation, whether it's going to be conducted by in-house counsel, those acting at the direction, or outside counsel, to understand again, who is the client. In many instances, it's the audit committee. And that's memorialized in the audit committee charter, maybe the board, though it could be HR or others. Who is your client? Who is the attorney providing the legal advice? Are there non-attorneys on the team that will assist in the gathering of information in order to provide advice? Many times there we see compliance department people that are non-lawyers. They need to work at the direction of a lawyer. A lawyer needs to direct their work and receive their work product in order to protect privilege around those communications. So think about a compliance employee, non-lawyer, interviewing a fact witness, an employee in your internal investigation. Your board of directors will be an audience. Your outside auditor, who does not protect really or care about your privilege, will be an audience. Your stockholders who might want to make Delaware 220 book and record requests, might be kicking the tires on a derivative or a securities class action. Of course, plaintiffs' counsel who would represent them, regulators, SEC, DOJ, CFPB, and whomever. And of course, law enforcement in nasty, wasty scenarios that we don't want to think about. So first principles are key there. Who is the client? Who are the attorneys? What is the legal advice being provided? You want to make sure that you are thoughtful about scoping and documenting the scope of your investigation, that you are investigating for a legal purpose, to provide legal advice to the client, and in the right circumstances that you are anticipating potential litigation. If you do not, there are cases, including the RPM, SEC versus RPM international case, and you'll see that here in a later slide, where courts have considered and sometimes found that an investigation was not, or parts of the investigation or documents in the investigation were not protected under privilege because they were not serving a legal purpose or providing legal advice. Reed, can you go to slide 21? So when you are conducting your internal investigations or your outside counsel, ask healthy, robust questions around what's your plan for interviews? What's your plan for note taking? You want to make sure that there's a select set of note takers, that you don't have competing note takers making competing sets of notes and storing them on different servers in different levels of draft. You need a very rigorous, orderly, planned process. When I was an in-house counsel, something like you need a really, really orderly, rigorous process sounded really expensive. It doesn't have to be. Good investigators know how to do this, and they know to make sure that their notes are stamped, like you'll see here on slide 21, to say, hey, anybody that reads these notes, these are privileged, these are draft, these are not transcripts. If you make something that reads like a transcript or a witness statement, you are inviting a court to allow discovery of it. Do not take down every word or every other word a person says, because then it's going to say I, we, they, us. And that's going to sound like a discoverable witness statement, which is going to expose your notes in litigation to a privilege waiver. Anyone that wants this stamp, just email me or call me. I'll be happy to share it with you. Just the big key there is be judicious in taking your notes. Make sure that your notes reflect that they are not only privileged, but work product and for an investigative purpose to provide legal advice to your client. You can go to the next slide, Reed. When you're in a virtual environment such as this, I said earlier, upjohn notices are key. We know that when we give an upjohn notice to an employee we're speaking with, we're saying, employee, thank you for sitting down and taking the time to speak to us. You need to know I represent, in this instance, the audit committee. And that is who has the privilege. And what you say to us may be shared with, will be shared with them, and with their authority may be shared with others. You are not represented by us, and you do not enjoy privilege with us. You need to protect your client and go further right now in a virtual environment. And you need to make sure that you have the witness say, I am the only person in the room. The walls are thick enough that people next door cannot hear everything we are saying. The door is closed. People are not walking by and hearing. I have not hit record on my iPhone. I am not recording by audio, and there is nobody sitting off screen listening, taking notes, or making a recordation themselves. You need to know where people are when they're giving their interviews, and you need to interview them on video if at all possible. I want to take a quick second. I know we're getting close on time, but a great way to protect and think about privilege in a thought-forward way is your ethics hotlines. So Ethics Point and other compliance hotlines. Do you have a feature on there that provides an upjohn or a soft upjohn to an employee who may be making a submission? Can they click a box that says, I am seeking legal advice in this submission. Please send it only to legal. Who receives those complaints and concerns? Can you protect them as privilege? And I'll call your attention to the Freescale semiconductor case on this slide, where the first communication into a hotline was not considered privileged by a court. Later communications were, because the handler was working with the person to provide legal advice to the company, but the original complaint was not able to be protected as privileged.
Hey, Reed, because of your Wheels Off survey that you did earlier, perhaps the rest of the time would be better spent maybe answering some of these questions that appear to be
Oh, sure.
lined up.
Yeah, I'll shut up. And we're getting questions about the PowerPoint.
There's
I'll look to Bill
one-
Banowsky, who has slightly more gray hair than I do, but I'm perfectly comfortable sharing the PowerPoint.
Oh, yeah, we will be sharing the PowerPoint with you. We also got uh, what would have otherwise been a handout that we're going to give you that basically summarizes all of what we've told you and more into basically 50 rules. It's a two-sided, one-page document that just helps you remember that, and you'll be provided with that as well. But are there any uh, good questions lined up there, Reed, that you think we should address before our time is up?
So there was a question that was earlier on that I was going to try to cover during my portion talking about litigation.
Okay, well, why don't you ask that question and then
Yeah, we were going to save the best for last, but I guess we'll save the best for next time. The question had to do with, if you're dealing with a large multi-state corporation and conflicting state law on which test applies, how do you determine the applicable in-house attorney-client privilege? And I think that the answer to that is unfortunately a difficult one, likely going to be in the state or if it depends, going to depend on whether you're state court or federal court, and then also whether the court views those laws as procedural or substantive. So I think unfortunately that's kind of a state by state analysis. However, I think that a lot of what we're saying is generally applied. While there might be some nuances between Texas's attorney-client privilege rules and in California are different, I think these general kind of ideas and practices are pretty much the same. And so I think as long as you can kind of have a uniform sort of way throughout the company, whether it be this state or that state, I think that's probably the best way to try to protect you. But Bill's giving me that look that he disagrees.
This can be a real bear trap because the privilege is defined by the rules of evidence.
Mm-hmm.
And are the rules of evidence substantive law or procedural law under the Erie Doctrine, as we all learned in law school? And so if you're in federal court in Texas, federal courts generally view questions of evidence as questions of federal common law. Well, if the privilege is defined in the evidence rules as opposed to a substantive property right, if you will, they're going to look to the federal rules. But I think Reed is right in that generally a result will rarely turn on the differences in a particular state law that especially you would, if you're in Texas, but like if you're sued in Minnesota, it's going to be Minnesota rule of evidence. Now, the rules of evidence now are getting more and more uniform, so it may be the same as the Texas rule, but it's a difficult question to answer, and it certainly is difficult to answer in advice in advance because you don't know where and when and in what forum is the privilege going to be challenged.
We have another question about, in our last couple minutes, our internal messaging, IM, Slack, Microsoft Teams, et cetera, treated more like traditional text messaging. What I will say is that in my experience at the regulator and since then, case law and how I've actually dealt with it with regulators is that they see it as a record. If there is a record, they see it as a potentially discoverable communication in record. And so if Jessica, in-house lawyer, communicates with Bill, outside lawyer, or really Bill, COO of my company, and I'm providing legal advice, we would still make all the same arguments of why that instant message is a privileged communication. But as we all know, that's a more casual place for conversation to happen, maybe complaints, maybe other sort of color. So we obviously recommend not communicating legal advice over those channels, and also having a company policy on whether you retain or do not, whether those get flushed at the end of a 24-hour cycle as part of your document retention protocol. And do you suggest that non-attorneys, i.e. investigators, provide a variation on the upjohn that they are working on behalf of the law department? Yes. Good question. And I believe the answer is yes. We do recommend that. Guys, we love talking about these things, and we've talked longer than we should and not nearly as much as we meant to. And so we want to be respectful of your time. Apologies that we didn't get through it all, but please know that Reed and Bill and myself and our teammates here at TK are open doors for you to walk through virtually. Put your mask on if you come anywhere near me. But we want to be here for you. So we'll make sure that we can get that PowerPoint and other materials around. And we are a phone call or an email, but not an instant message away.
And we have trained executive teams, or usually a broader than just the executive team, really teams of people that use the legal department on what the rules are and how narrow it is. And we're certainly available to do that over lunch if that's something you think might be helpful. It's often people will listen when outside counsel tell them something, when inside counsel may be telling them the exact same thing. It's kind of like your children. So we're available to do that, and we'd be happy to give a primer on the basics of the attorney-client privilege.